Karen literally came running into my office, telling me that she had to take her husband to family court. She explained in detail that her husband was paying way too little child support and spousal support to her, and he would not cooperate on important decisions that had to be made about their kids. After she gave me the background on her situation, I told her that we can take her husband to family court, but we should first try to negotiate a separation agreement with him. Hi, my name is Thomas O'Malley. I'm an experienced family lawyer in Durham region and the GTA. You should only take your spouse to court as a last resort. Court is very expensive, time-consuming, and it can be a serious emotional burden for you. I highly recommend that you try to negotiate a separation agreement with your spouse before you consider going to court. A separation agreement is generally less expensive and takes less time to complete than a family law lawsuit in court. You also get much more flexibility in a separation agreement than you will ever find in court. You and your spouse can carefully craft terms and provisions in your separation agreement that protect your legal rights and deal with your specific concerns than a judge will ever craft in their court order. You are also always taking a chance in court, regardless of the strength of your case. When you have negotiated a separation agreement with your spouse, you know exactly what you're getting, respecting every issue from child custody to spousal support. But you truly never know what a judge will do in your particular case, in a trial or in court in general. Your lawyer can give you an excellent idea about your chances in court and what a judge will order on the different issues. However, you can never know with certainty what the court will order. In other words, you're always taking a chance when you put a case before a judge. You're not taking a chance when you have a negotiated separation agreement that contains terms and provisions that you can accept on the various issues in your case. You know exactly what you're getting in your separation agreement. However, you should be prepared to go to court quickly when your spouse is not cooperating in trying to settle your case with a fair and reasonable separation agreement. When your spouse refuses to provide full financial disclosure, or they are unreasonable on the various issues in your case, and they continue to be unreasonable, you should seriously consider just taking your spouse to court. I've had a number of cases in which my client's spouse is acting unreasonable when we are first trying to reach a settlement with a separation agreement, for example. Then, when we go to court on the various family law issues, the other spouse suddenly becomes more reasonable, and we can often settle the case shortly after we start the court process. As I often tell my clients, we often have to go to court to get a settlement. At first, this may sound strange, but it is not when you think about it carefully. When you start the court process in your separation or divorce, your spouse quickly realizes that you're serious about this matter. They realize that you're going to stand up for your legal rights, and they often become much more reasonable so that you can reach a settlement. If you have any questions about your separation, divorce, or family law case, and you'd like our help, feel free to contact me on my Facebook Law Office page, that's O'Malley Family Law, or call me at 905-434-8837, and I'll point you in the right direction. Please make sure to share this important information and video with your friends, family members, and coworkers.